Hello, good morning, everybody. I'm so excited to have all of you today. We've got a wonderful webinar this morning focused on demystifying open source license notices with automation and with our esteemed guest, Heather Meeker. So I'll start off with a quick set of introductions and then we can get started right away. So my name is Kevin Wang. I'm the CEO of FOSSA, and FOSSA is an open source management platform. We help companies like Uber, Verizon, and Twitter automate and drive audit-grade open source compliance at scale through their daily workflows. And so for content today, open source compliance is a huge challenge and a major focus of ours. And the mechanics of it are especially complex today with the speed and scale of modern software development. And so there's, usually an overwhelming amount of technical knowledge and experience needed to prepare for handling attribution notices, properly creating bills of materials, and standing up automation tools. And so that's why today I am super excited to welcome our guest, Heather Meeker. Heather is a partner at O'Melveny & Myers and one of the forefront experts in the world of open source licensing. She was one of the original authors on some of the major licensing options that we have today in the world of software development, including the MPL, the Mozilla Public License, and now the Polyform licenses. And she is also the author of the book, Open Source for Business, and we will be sending some copies out later today after this webinar. Thank you so much for joining, Heather. We appreciate it.
Thanks. It's a pleasure to be here.
Awesome. Well, we're thinking about some really, really great ways to kick off this webinar. And I think we could just get started with just some general wisdom from somebody who's been doing this for a very, very long time. And so I guess my first question would just be, how did you get involved in advising on open source?
Well, that question, we have to go way back to the 1990s when I first started practicing law. And I was doing software licensing, just sort of general software licensing. And when it came to be around maybe 1997 or so, I'd just been practicing a couple of years. People started asking me about open source licenses. Clients started asking me. And at the time, most intellectual property lawyers took the view that open source licensing was too dangerous to use. And the reason they thought that was that it didn't come from a commercial vendor, so it wasn't supported by sort of commercial indemnities and so forth. And so their advice generally was don't use it. But I figured out pretty soon, because I was working for a lot of startups, that wasn't the right answer. The answer had to be something more nuanced, like, well, you can use it, but you have to do these things and you should consider these risks. And because I was maybe willing to, go out on a limb a little bit, people kept asking me about open source licensing. And what I like to say is, if you're in an organization and you know 10% more than the person in the next room, you're the expert. And so people kept asking me more and more questions about it. Also, I thought it was a fascinating area. I mean, basically like the GPL was a hack on copyright law. It was very interesting to me how it had been done. So I just kept finding out all I could about it. At the time, there really was not a lot of information out there about open source software licensing. It was difficult to find information, particularly sort of objective information about it. So I just kept working at it. And I thought that it would be the flavor of the month and go away one of these days. But then it just got bigger and bigger, probably fueled a lot by the internet bust when people were like really moving to make savings and so forth. So that's how I got into it. Mainly it was interesting and I was willing to answer questions about it. But I think, when you look at careers and how people get to where they are, that's often sort of the path that they take as well. I thought this was interesting and I was willing to do the work.
Well, yeah, I mean, I think many people consider you, one of the real early adopters in the world of law when it comes to thinking about open source. And I love the comment you made about how, some of these original licenses were just these big hacks. And in some ways, open source itself is, just one of the big hacks of software that stuck around. And when I think about, the past couple of decades or, how long you've been involved in this universe, I mean, intellectual property law is a large and really rapidly evolving field. The world of software itself is changing every single day. And, I think a big question for the audience would just be, how should today's modern IP lawyers be thinking about open source?
Well, the one thing I would say is that open source is no longer the exception. It's becoming more like the rule. So it used to be that intellectual property lawyers were focused on, say, proprietary licensing and patent licensing. And sure, we still do that. But I think we've gotten to the point where understanding open source licensing and other kinds of open licensing too, is something it's a necessary skill set for intellectual property lawyers today. Because when you look out at what the technology landscape looks like today, an enormous part of it is open source. Every product has open source in it. Every product has software in it these days too. Yeah. So it's changed from a niche area to a necessity. And that's mainly what I would say, understanding at least the basics about it is a core skill for IP lawyers.
Mm-hmm. That's great. I mean, we definitely, there's this famous quote out there about how software is eating the world. And I think these days people are saying open source is eating software. And I think there's a ton of truth to it.
Yeah, I think many people who are not focused on this don't understand that they are using open source every single moment of every single day and that it runs the infrastructure of the world.
Mm-hmm. Absolutely. So, when people get involved with open source and start doing open source compliance work, usually one of the most common things they end up getting asked for to either talk about or explain is license notices. And I think this is a great topic for us to cover. So maybe we can start off with just me asking you about why you think license notices are important for open source software.
Well, so for many open source licenses, the permissive ones, the notice is really the only requirement of those licenses. So if you think about what the deal is, the social contract, if you will, between the developer who wrote that code and you who are using it, all they asked you for was to comply with the notice requirements. And so just from a good citizen point of view, complying with the notice requirements is key. When you talk about copyleft licenses, which have a lot of other requirements too, I think of that, well, it's the same thing, it's part of the social contract, but also if you're managing risk within an organization, the one thing you can do to increase your risk the most is not to do your notices properly. Because if you don't do them properly, that's a very easy thing to suss out. And so if an enforcer wants to take issue with what you've done, it will be very easy for them to show that you violated the license. So this is the part of open source compliance that is sort of intellectually the easiest. It's maybe the most difficult from a pure process point of view, but you really owe it to yourself and your company to do this right in order to manage risk, and also you owe it to the community in order to fulfill their expectations about what they wanted when they gave you this software for free.
Mm-hmm. Right. Well, from a process standpoint, that's one of the big challenges out there, and today, developers use so much open source, and usually trying to identify all these notices and the requirements and making sense of all of these things isn't always straightforward. And so, one thing I think about is, when we look for license notices and license related files inside of an open source package, we're cracking open a big package of code. And inside of that code, we see files that say copying, we see files that say license, we see other files that say notice. There are other files that just have copyright notices in line. What are some of the differences between license notices and copyright notices?
Yeah, a lot of people get really confused about this. And by the way, I think one of the sources of the confusion is that you will actually see in projects a text file called copyright.txt, which has a license notice in it. So there's a difference between copyright notices and license notices, and it's really important to understand it. It's not difficult to understand at all, but people will tend to use those two terms interchangeably, and that's very confusing. So a copyright notice is, you've seen this on all sorts of stuff. Copyright 2020, Heather Meeker. If I wrote something and I wanted to put a copyright notice on it, that's what I would put. In the law today, copyright notices don't actually mean a lot, right? They're useful to use, but they don't have the legal meaning that they used to have, years and years ago. So they tend to be kind of, afterthoughts from the point of view of the law. However, because they mention the author's name or the copyright owner's name, they serve as a kind of proxy for attribution. And that's very important to lots of people, even though maybe it's not that important from a legal point of view. So that's the copyright notice, is that little statement with just the word copyright and the copyright owner and the year of publication. And then there's something quite different, which is a license notice. And the license notice is what tells you the terms under which the copyright owner has made the material available to you. And that's obviously much longer, ranging from the very short BSD license to the very long GPL3 license, right? So when you're dealing with this stuff, you have to keep in mind that there's a difference between the two. And you'll even see that some of the licenses say, if you redistribute this code, you have to include this copyright notice and these terms. And those are actually two different things. The licenses that say that are actually referring to both the copyright notice and the license notice. But yeah, they're both important. But when you talk about doing notices, you're mostly talking about doing license notices, and the copyright notices are often baked into them.
Mm-hmm. That makes a lot of sense. So, in the practical world, when we end up, understanding and processing all this information, processing all of the code that developers end up using, at the end of the day, we're asked to produce some license notice that we have to give out to somebody else out there in the world. And I am sure you have done countless numbers of these in countless different situations for countless different kinds of companies. And I just wanted to ask, in your practical experience, why is assembling license notices so hard?
Well, so first, they're hard because there can be a lot of them. I mean, the sheer volume of open source packages that people use in products today, it's like it just gets bigger and bigger and bigger. So as technology marches forward, it's possible to engineer software in such a way where you're taking advantage of pre-written modules, much more than you had, than you could maybe 20 years ago. As time marches on, there's more and more use of standardized code modules, most of which are open source. So, it's not unusual for me to see a product that one of my clients is selling that has hundreds or thousands of notices in it. Now, just that sheer number of notices to manage means that it gets pretty quickly outside of the ambit of the ability of humans to do it very well. And so unless you use automation to do notices, it can be very difficult. Now, I should explain that, there are different ways to go about delivering notices, and they range from the extremely time-consuming to the less time-consuming. But what people used to do a long time ago was they would deliver a binary product, and they wouldn't deliver source code. Maybe they'd do offers if they had to, but they would put together a file that had all of the open source notices in it. This is the way most people did it, maybe back in the 90s and early 2000s. And that is a ton of work, because what you're doing is you're taking the license for every single component, plucking it out, putting it in a file, maybe formatting it somehow. You don't have to, but people do. Maybe deduplicating notices. So that becomes extremely time consuming to do, particularly if you're doing it as a human. There are different ways to do it. that might involve, delivering lots of different notice files instead of one big notice file, delivering the notices within source code instead of within binaries, maybe not doing so much work to deduplicate and so forth. But that it's very challenging. The more you actually have to do, the more human intervention has to take place with the notice, the much more difficult it is. And I would say that if you're doing a product that has more than, say, I don't know, 20 or 30 notices in it, doing it via like just human intervention, it just becomes untenable very quickly.
Yeah, I can't even think of many modern software products that only have 20 to 30 open source components.
Not many. It would have to be something very small, like maybe with mobile apps. And by the way, notices in mobile apps is an area of rampant non-compliance, right? But you do need to use the notices in mobile apps. That's a kind of product that may have a small number of components in it, or maybe just a piece of software that's very small. But like, if you have anything like a Linux like system in a product, which many products do, you're talking about hundreds and hundreds of notices just as the baseline of the operating system, much less everything that you're including in application layers.
Oh, totally. And, I think two of the kind of really interesting components or flavors in software development now are, really the scale at which open source is getting used, but just also the speed of changes. And so, in many, many development teams, you don't have these kind of singular events where you're packaging a binary and you can give it out to the customer and have some sort of guardrail. But the entire development process is constantly moving. Code is going from change to arriving in front of a customer dozens, hundreds of times every single day, potentially. And so, I think robots are winning the war.
Yeah. I'll tell you a slight little war story. I mean, when we first started figuring this stuff out long ago, and, people were still trying to figure out, the processes for doing this stuff, I actually had a number of clients who would put, say, open source licensing notices in a paper manual for an automobile, right? And in fact, if you look in your user manual for your automobile, like most of them still get delivered with a paper manual, right? You may find open source notices in the back of that. Now, I can hardly think of a more horrible way to do notices in a product. Expensive, difficult to maintain. There's a long lead time on doing paper manuals and so forth. And so that's really an extremely time consuming and expensive way to do notices. But, if you look at some of the old licenses, some of them, not many, because most who said this have been deprecated, but some of them said, you have to put this notice in the user manual for the product. Well, I mean, we've moved to a situation where user manuals at a minimum are not paper anymore, right? And a lot of times they don't even exist because the user manual function has been absorbed into, help files in the program and so forth. So, we've come a long way from the situation where we assumed that we were going to stick something in the back of a paper manual to today, where there are a lot of different approaches to doing notice compliance.
Yeah, the ones that sort of we see the most often are starting to get really creative. They're about embedding the notices directly into the application experience. I'm sure if anybody here has, phone or apps inside of it, you can go to every major app, Spotify or these things, go in the settings page and find some sort of open source license page. And usually that process nowadays is fully end-to-end automated. So when a developer uses a new piece of open source, that page gets updated automatically once there's a new distribution.
Yeah, it's super important because unless there's some kind of automation there, it's very easy for the product to get out of sync with the notices. And once that happens, you're actually not compliant anymore. So it's not just creating the notice files in the first place, but updating them in a DevOps environment. It's a lot of work, and without automation, it's really difficult to do.
Yeah. It's incredible that there's still paper manuals out there. There's some hero at every single one of these companies that's responsible for doing this. Some
Yes.
hero.
And they require a fair amount of lead time too, right? You can't just push a paper manual out the door. It takes a little bit more lead time than something that's done in electronic form.
Hmm. So what are some other just common misconceptions about license notices or mistakes that you commonly see these days when people are approaching the production of them?
Well, there are a lot. I mean, let's see. One of the things I hear a lot is, "Oh, we don't have to use the notices for this thing because it's only a dependency, right?" Okay, so no, that's not right. I mean,
Right.
what matters is whether you are obligated to deliver the notice, and usually that's triggered by distribution in most open source licenses. So the problem is that if you have selected to use a specific component and it sweeps in lots of other components, you also have to comply with the notice requirements for all those too. So it becomes an increasingly difficult problem. So the dependencies create an even bigger information problem than just whatever your bill of materials is. And then another thing that's caused a lot of confusion and consternation, even though it's wonderful from a technology point of view, is containers, right? Because when you pull software in from a container, that container usually has tons of open source software in it, right? And so you're obligated to fulfill the obligations for everything in that if you're distributing it. And often, well, particularly in the early days of containerization, there was a lot of non-compliance in the containers. So people were pulling containers down off the web and they didn't have any open source notices for them at all. And then they're putting them in their products and pushing those out the door. And so that's a completely non-compliant product. So that's a big misconception is, I only need to focus on whatever is on my bill of materials and, not anything that's kind of embedded in it. You're responsible for complying with the licenses for all the software you're distributing, no matter who made the decision to integrate it with your bill of materials.
Yeah, totally. When I think about like a great analogy for, or conceptual model for a modern software product, I really think about an iceberg. Because in most software products these days, the actual direct code getting used by developers or direct code that, proprietary code that developers create themselves is usually now just the minority. Like the majority of all code inside of these software products come from third-party code usage that has more third-party code inside of it, that has more third-party code inside of it. And so I totally agree. We talked a little bit about some of the best practices in modern practices of creating notices, embedding things with an app, moving away from paper manuals. And, there are a whole variety of ways that notices can be produced. One of the ones that you've mentioned is producing notices in source code. And there are other ways of producing notices for binary products. I'm just curious to get your thoughts and advice on what some of the best practices are in those sorts of environments.
Well, so the best thing you can do as far as notices goes is usually to deliver source code. So when I tell clients this, they're sometimes a little taken aback because many of the open source licenses don't require them to provide source code. But in reality, when people use open source software, almost all of it they use completely unmodified from the upstream source, right? Some they modify. So with respect to code that they're not modifying, they shouldn't have any kind of business sensitivity about delivering the source code for that software. It's not giving away any secrets or anything like that. So I normally tell them, unless you have some specific business reason not to deliver the software. And when I say that, I'll just, say, for example, if you've taken some software under the Apache license and you've changed it because it's a permissive license, you don't have an obligation to provide your changes, right? It's unlike a copyleft license. So in that kind of case, maybe you would have some sensitivity about it. But the fact is that that actually happens in a very small percentage of the use cases for open source software. So if you don't have any business sensitivity about delivering the source code, the easiest thing is to deliver it upfront with your product, okay? Because when you do that, the notices are baked in there. You know, the notice file is actually in the source code. I think, by the way, that's something a lot of lawyers don't understand because they're not developers and they're not accustomed to like looking at the source code for the software. But if you actually look, say, in a GitHub repository, normally the license file is just going to be a text file in the top level folder of the repository. So if you make the whole repository available, then you've already delivered your notice files, okay? People run into difficulty doing a source code delivery depending on what their sales channel looks like. So if I'm, say, selling application software, it's usually super easy. I can easily provide access to the source code upfront with my product because the amount of room that source code takes up, even though it can be large, it's often trivial from the point of view of delivering the software. Or at a minimum, if you're offering the software by download, you can say, click here for the source code, right? And then you have fulfilled your requirements. So that's the easiest thing to do. People get into difficulty with notice requirements when either they don't really know what's in their software. By the way, that's really bad, right? For a lot of reasons other than licensing. Like, you need to know what's in your product, because if you don't, you can't, you know, be reasonably sure that it's secure. You can't be reasonably sure that it's up to date. You know, so you do need to know your bill of materials. Obviously, you need to know your bill of materials in order to deliver the source code for it. But if you can deliver the source code up front, that's great. Now, sometimes that's difficult because, let's say, you're delivering the software over a small pipe of some kind. And so actually delivering the source code might take up a lot of room or time, right? So that's one challenge. Or, you know, the classic problem with delivering notices is IoT, anything embedded, because where your product does not have an actual user interface, you have a hard time delivering source code. You know, maybe actually impossible. So then you have to have another route by which you're delivering your notices, because you have to deliver those with your product. And B, if you have to make source code offers because you're only delivering binaries, then you need a route for that. So then that requires some extra compliance infrastructure to be created in order to actually, you know, fulfill the deliveries that you have to do under the licenses. You know, those are the problems that people usually experience when they're doing notices. It doesn't tend to happen as much in enterprise software. It happens a lot more in consumer electronics, any kind of embedded software, any kind of small systems where it's unfeasible to deliver the source code up front.
Mm-hmm. You know, and in those environments, especially when you're delivering some kind of binary or something like that, what are, you know, some of the best ways to deal with those things? Can you just put a notice on a web page? Is that acceptable for a lot of the licenses out there? Like, what are some of the best practices that you've seen?
Yeah, so one of the questions I get from clients, I probably get this question at least once a week, is, can't I just put these notices on a website? Wouldn't that make sense? Well, it might make sense, but it's actually not what most of the licenses require. So so first of all, let's say, you know, in the average situation, you're dealing with, you know, 20 different licenses. Okay, that would probably be small, but, you know, you've got hundreds of components and they're under 20 different licenses. Okay, so each of those licenses has a slightly different notice provision in it. So Normally what people do is they comply with the notice terms of GPL. And the reason they do that is that GPL is kind of a, it's kind of a bellwether in the sense that if you comply with it, then you're probably complying with most of the licenses, you know, but GPL, of course, version 2 was written before, not really before the web, but before people were really using the web broadly. And so it is based on an assumption that people don't have web access. So what it says is you have to give a copy of the license, which is about 8 pages of text, with the product. It doesn't say you can put it on a website because websites like weren't a thing then. Now we move to the situation today where it's a reasonable assumption that most people have web access, and yet the notice requirements of most licenses do not allow delivery of notices separately on a web page. It might be very helpful to people to have it on a web page, but the licenses don't specifically allow it. So, for instance, if you are distributing a product by digital download, you can put the notices on a web page because it's the same place, right? But if you're delivering it physically, you have to figure out how to get the notices in the product. And, you know, there are a wide variety of strategies to deal with this. And you're always basing the risk that someone will think you violated the license against the cost of delivering a bunch of notices and potentially delivering them in a way that is of no practical use to the recipient, right? And, you know, for the most part, I mean, the next question people usually ask is, well, what if I put my notices on a website? Am I really going to get in trouble for that? Even though the licenses, you know, just can't do compliance. Honestly, because most of the enforcers of licenses still today are so-called community enforcers. And so what they're doing is they want you to comply, but they're actually kind of flexible about this stuff, because what they want is for people to have access to the source code in the way that the licenses require. But there are some, you know, but when you get to somebody who is not a community enforcer, who is a so-called copyright troll, or is your competitor who's coming after you for violating their open source rights, they are, you know, potentially going to go after you for footfalls like that. So it's always safest to make sure you're literally complying with the licenses. But yeah, there are a lot of other strategies. For instance, people who are doing enterprise sales, they can, you know, they have a contracting process with their customers. And so they can actually deliver the notices in the contract or, you know, some separate way. It doesn't have to be baked into the product because they can provide them sort of with the product, but just not on the same actual like physical delivery device. That's fine, right? But when you're doing consumer sales in particular, or you're just giving something away, that's when it gets really challenging.
Absolutely. Yeah. You know, the way that we see that really often, and kind of the way that I've learned to think about it is it's about compatibility between the notice delivery strategy and also just the delivery channel of the software.
Right. And it really depends on how your sales channel works. There's a huge spectrum of practices. And you just have to figure out how to get those notices out there in a way that, you know, is in or with the product. And that's usually about all you have to go on for the notice requirements of open source licenses.
Yeah. You know, one thing that's quite interesting is, especially at very, very large companies, the sheer number of SKUs that you have and the sheer number of kinds of applications basically means maintaining very, very different notice generation strategies. Yes. So I could be shipping a binary in one team. I could be creating a website in a different team. I could be using containers in a different team, and each kind of has, depending on how worried you are about foot fouls, it can have very, very different implications for what the process should look like.
Yeah, another problem that a lot of my clients have is when you're working for a company that does a lot of acquisitions, you probably have a lot of business units, which were, formerly other companies that you acquired, or maybe even subsidiaries, and they've got a completely different process. So trying to get a cohesive process in a large corporate structure is, it can be really challenging to harmonize that across an entire corporate structure.
Totally. One thing that we often get asked about, and it's become a really popular topic in the world of notice generation, is SPDX, or Software Packet Data Exchange. And I think the audience would just be really curious, like, what is SPDX? How does it help? Is it a substitute for license notices?
Yeah, SPDX is a really great project. It's been in process for quite a while. It's pretty mature at this point. It really serves a couple of different purposes, neither of which are exactly license notices, but both of which are very helpful in connection with doing license compliance correctly, including notices. So the SPDX format, first of all, it's a format for delivering supply chain information. So if I have a product that has 1,000 open source components in it, how am I going to tell you, my customer, what's in there and what licenses cover it? Now, the licenses require me to give you copies of the licenses, but that's probably not terribly helpful to you, because all I have to do to comply with that is dump an enormous amount of text on you in an unstructured format, right? It's not helpful. So SPDX is a format for saying, here's the component, here's the license, and some other, meta information, so that the recipient can do diligence properly. And the world would be a better place if everybody delivered compliance information in that format. The SPDX is also another thing which is quite helpful almost independently of that. And that is, it's a list of licenses with unique identifiers for each license. And they're very detailed, like there's a different one for GPL2 and GPL2 or any later version, and GPL2 plus exception, and, all of a bunch of different forms of BSD and so forth, right? But it's a way to actually use a unique name for every license. So, I do a lot of M&A work and financing work and so forth. And in any kind of transaction like that, or in any transaction to sell a big product, in a commercial situation, you have to deliver diligence information to your acquirer, your investor, your customer. And SPDX is a great way to do that if the customer or investor or whoever is capable of using it. Even if they're not, using the SPDX identifiers in diligence information is very helpful to avoid confusion. Because if you look at your average diligence information response, well, I've seen some really bad ones, and I'm sure any lawyer in private practice has seen them. Right. But they'll tend to say things like, my favorite, so they'll say BSD, GPL, they won't say what version, they'll say ASL, which sometimes means Apache, but sometimes means another license, right? My favorite characterization of a license ever was GNU BSD. And then I, thought, okay, let's see what that means. So it's great that there's this project to try to standardize the way supply chain information is delivered. The industry is still really catching up with using it, but if you have the opportunity to use it, it's really an opportunity you should consider, because standardizing the way that you deliver information is always cheaper in the long run.
Right. I mean, it's, having this sort of canonical list, especially of identifiers for open source, is so important, especially for automation. When we were first building the platform, we kind of chose to make these SPDX identifiers a big first-class citizen for us, because, one thing about open source licensing is that there's huge variety, and there's no like police out there that says you cannot change licenses in a certain way. So any developer can take an open source license, arbitrarily modify it with one or two sentences to completely change the meaning or implications of it. And, and there's just this huge license proliferation problem. And when you try to build some automation around this stuff, having just some sort of canonical list, some sort of standard to be able to compare and contrast modifications and sort of understand which ones have deviated from the norm, I think is super, super important.
If I could do a little plug right here, there's also another list that may be of interest to people. This is a little bit of an aside, but like having lists of standardized information is hugely helpful, when you're doing license diligence. And so what I want to mention is the Blue Oak Council permissive list. So Blue Oak Council is a group of lawyers who are providing peer-reviewed information about open source licensing. It's intended to make people's lives easier. And one of the first big projects of that organization was to create a list of permissive licenses, because there wasn't one. And that's kind of amazing, right? Because whether a license is permissive is a hugely important question in license diligence. And while, BSD and MIT, everybody's familiar with those, and they're pretty easy to identify the small variations of those, there are a whole bunch of others that are a little bit whacked out, and maybe unique to one project. So what we did was we took all of the ones that were on the SPDX list, and I think there are a few others as well that were permissive that seemed to be, reasonably common out in the wild. And we just listed them all. We also rated them in case anybody was interested, because some are a lot better than others. But that's a real handy resource, because if you're doing diligence and you look at a license, you go, this looks permissive to me, but I'd really like a gut check on that. The permissive license list is a really helpful resource.
Totally. We've got a bunch of audience questions coming in, and I guess the final topic I'd like to cover before moving on to that is, we've talked a lot about the challenges of creating license notices, the variety, the scale, and also the role of automation. I think we'd all love to hear from you, just kind of some best practices or advice you have when thinking about automation, the most important parts of tooling, and, and how people should think of how automation can really help in this process.
Well, first, you should always use automation if you can. Even if you're a small company and you think that your information, delivering notices is an information problem. It's not usually a legal problem, right? Because the question of, once you get a process for actually delivering the notices, then the lawyers are kind of out of it. It's just execution. So you're handling this information problem. And even if you can handle it today with your, 20 open source components, one day soon, you will not be able to handle it anymore. For all the reasons we've mentioned, multiple SKUs, updates, products getting bigger, using more third-party components, etc. So you need automation. It's just a question of what you're going to pick. And, there are a variety of tools out there. Obviously, FOSSA is a great one, right? And I will just say some of the things that people should be considering when they consider automation. So you need automation. Absolutely. If you're not using automation, you're just in an interim stage before you use automation, right? But the things that you should be considering are, does the tool do the level of checking that you need, because there's a wide variety. Like, for instance, there's something called FOSSology, but it doesn't really check against ground truth at all. It's a really great tool for doing like some initial auditing, because all it does is like go through and look for license notices and copyright notices, but it doesn't find any cut and paste errors. So it's kind of a pre-automation tool almost. And then, you know, you have the more sophisticated tools like FOSSA that actually help you figure out if somebody has made a mistake somewhere, right? So that's one thing to consider, like how much of that do you need? The second thing is usability, because I can't tell you how many times my clients have gone out and gotten a tool and found it so difficult to use that they stopped using it. That's a waste of money and time. And it also, you know, when you go down that route, what you're communicating to your engineers is that you don't care about their time. That's not a good thing to communicate. And also, you know, keep in mind that the engineers, this is like for engineers, doing compliance is kind of like lawyers doing their timesheets. It's like, well, I did the work, but now I have to do the paperwork, and it's not their favorite thing to do. So having a bad experience like that actually can tend to cause less compliance in your organization. So yeah, I would say overall, does it do what you want it to do? And is it, you know, user friendly enough so you can actually get people to use it?
Was the thing made for humans?
Yeah, exactly.
That's awesome. Well, we have a ton of audience questions pouring in. I wanted to get a chance to move to some of the Q&A.
Sure.
So I will start with a couple right over here from the top. So is distributing an SPDX file with a product a valid replacement for a notices file, or do we still need a notices file? That's the first question.
Well, the licenses say you need the licenses. If you're using SPDX, chances are you're in a context where there will be a way to deliver the source code. And I say that because, like, consumer products don't usually have SPDX files because the consumer like wouldn't know what to do with them. When you're delivering SPDX, you're usually delivering to another rung in a supply chain, and so there will be a delivery code is probably so. It's not really a substitute. By the way, it's better than nothing, right? But that's a risk question for you and your lawyers to figure out. So no, it's just I consider SPDX more of a diligence tool than, you know, a notice delivery tool.
Mm-hmm. Makes a lot of sense.
But it's not impossible. Like, sorry, you could like deliver an SPDX file and actually find a way to, like, you know, link it to have an internal link to a license file, but that's not the way it's usually delivered.
Mm-hmm. Right. Yeah. I mean, we've seen license notices where there's SPDX identifiers within the notices or summary sheets or pages that include SPDX information. You know, a lot of the times when we're asked for something specifically like an SPDX data file, it's usually something that's consumed by other tools or other machinery in order to generate the kind of higher level
yeah, exactly. What gets delivered to the end customer is rarely an SPDX file. That's usually delivered within the supply chain.
Okay. Another really important question. So recommendations on how to get buy-in from your org on the importance of tracking bill of materials internally. This is a really big one. I have my own opinions on this.
It's a big one. Well, what I always say is, you know, license compliance is only part of the job, right? And if you have license compliance issues, you have other issues too. And the top one is security. You know, the biggest resistance that I see in organizations is keeping track, right? Because it's such a big job. And, but there are many reasons to keep track that are engineering reasons that have nothing to do with license compliance. So when you can communicate that this is all part of one big, effort to make your products excellent, that's the best way to get buy-in from people. Another thing I'll say is that, your company may have, say, an open source compliance policy or process in addition to the tools that you're using. And I always tell clients that a good policy, like the policy might be, you can only use LGPL code in our product if it's a dynamically linked library. Some things like that. If you've looked at license compliance policies, you'll be familiar with use case rules like that. Those rules should handle 95% of the cases. Like, a good policy means that legal does not have to get involved in most of the decisions, because in truth, most of those decisions are engineering decisions. Like, when you're deciding to use a component in a product, that's a decision that is the right component from a technical point of view, security point of view. It's going to be properly maintained, and that it's going to be compliant for a license, from a license point of view. And so what I wanted to communicate is these decisions are mostly owned by engineering, and they're not legal decisions. And so legal doesn't have to be a bottleneck. Legal should be somebody that you come to for advice in a gray area. Like, for instance, I want to use this component and there's no license associated with it. Like, that's a legal question, and there are various ways to address it. But that's not an engineering question, right? But all the rules about open source compliance that companies are generally using, those are engineering rules, and they really should be characterized that way and stay within the engineering function. I think once you can communicate that and really make that happen in your organization, you find a lot less tension and resistance to the compliance processes.
Right. Yeah, I couldn't agree more. I think one of the most important pieces is getting buy-in and recruiting buy-in from the engineering organization. And really the value prop of tracking bill of materials internally is something that's a really no-brainer value prop, I think, for any large organizations, right?
Yeah.
You're distributing a ton of software and you need to know what's inside of it. And it's about creating a real-time inventory of what's inside of this thing. And it's useful for a variety of cases, for compliance, for security and vulnerability management, and then also just for engineering efficacy and understanding what's going inside of the code. And so, I think when we've recommended approaches to this in the past, I mean, first, the value prop is a bit of a no-brainer, and then second of which, the process for creating bill of materials, tracking it, the automation around it just has to be exceptionally developer friendly and
Yes.
kind of native to the development workflow.
I would maybe a small analogy. So if you're a lawyer and you do transactions like I do, we do things the same way programmers do. Like, we don't write anything from scratch. We use this indemnity provision and this warranty about privacy and so forth. We put together our agreements. And just imagine what would happen if you never checked to see which provisions you were using, right?
Right.
And then, say there was a new privacy law like we have in California, like all your agreements would be broken. So it's the same kind of process. It's absolutely essential to know what you're using, and that should not be difficult to explain. The thing that's hard to sell is to convince the engineering team that you are respecting their time and their skills by making the process livable for them.
Mm-hmm. Absolutely. We've got another really great question popped in a little bit earlier. So, does hosting software at AWS constitute a distribution and trigger for open source licenses? What about moving from one server to another within a data center?
Oh my goodness. Well, so I have to say that in a way, there's no answer to this question. There's no like certain legal answer to this question because there's just not enough law on the topic. To make a long story short, the Copyright Act doesn't actually define distribution. I don't want to make anybody lose sleep at night, but it's true. And most open source licenses have obligations that kick in on distribution. It is a right in the Copyright Act, it's not defined. You have to kind of piece together legislative history to define it. So, with that caveat in mind, that like it's almost impossible to actually say the legal truth. The answer to your question is no, that's usually not a distribution. And we come to that conclusion, in a number of steps. But bottom line is no, probably not. And it has to do with the fact that you probably control that virtual space. And it's really more about who controls the virtual space than like who owns the computer that it's on. I'm not saying there aren't other arguments against that position. That's basically how it's shaken out in the industry. I mean, it cannot be the case at this point that every use of AWS is a distribution because the world doesn't work that way.
Well, on that topic, I mean, the concept of redistributing is often one that's very confusing given the variety of how code moves and software moves around the world. There's this other question that popped up that says, when we say redistribute, is there a commonly understood or sort of canonical meaning? For example, does it apply to SaaS? What's sort of the best way I think we can think about what a redistribution event usually looks like?
Yeah, so SaaS in the way that most people use it is generally not considered distribution. And I'll explain why. So SaaS is you have some software, you're running it on your own computer, but you're allowing somebody remotely to interact with it. That person does not have a copy of the software. That person does have some software, and we call that client-side software. So when you use a web page, let's say you're using an e-commerce site, sorry for everybody who already knows all this stuff, but when you're like filling in your phone number and it says, no, that's not a valid phone number, what's happening there is that there's actually software that's executing within the browser on your machine to do that checking of the data entry. And in fact, the whole web page that you're using is written in HTML. There are three languages that are very popular: HTML, CSS, and JavaScript. So almost every big web page that isn't just static has all of those things on it. That's actually all distributed, but it's a very small portion of the software that's being deployed in SaaS. The stuff that's on the back end is not distributed. Now, I always tell clients, relying on the fact that you're not distributing in order to be compliant is a bad idea because someday you're going to distribute that software. And the thing I like to say is that when a salesman comes in and says, I have this multi-million-dollar deal, but what we have to do is allow the customer to run their own instance of our SaaS on their system because they're in a highly regulated industry or whatever, right? That's distribution. And you don't want to be the lawyer who has to say, gee, I'm really sorry that we can't do this multi-million-dollar deal, but we can't because we have completely abdicated open source compliance because we thought it was okay because we weren't distributing it. I have rarely had a single client that didn't get to that distribution point at some point in their business, either because of that or they're doing a joint venture or something like that. So you should not, just decide that it doesn't matter, right? But you don't have to do all the notice delivery and everything like that for the stuff that's on the back end of SaaS. Stuff that is in the client side, you actually have to do notices. And that's a completely different argument with your engineering staff about where they're going to put those notices and how much they hate putting any kind of extra space in the web pages that get delivered.
Yeah, I mean, discovering what ends up getting distributed in that environment is a challenge. It's also why I find it so important to maintain a bunch of different sets of policies because the conditions of a specific project can change a lot. We have a bunch of other questions, but time for one more. And I found a particularly fun one that maybe we can wrap up on. So, the last one we'll take from the audience is a few open source licenses out there have oddball clauses that are vague, but perhaps harmless. Examples are JSON, which says, do good, not evil, or the WTFPL, which is do WTF you want, not a real license. Right? So what is your practical take on all these oddball terms and weird licenses?
It's interesting to mention those two, because both of those two, I regularly tell clients, these are okay to use. And the WTF license, like, okay, maybe we don't know what that means, but what we really know is that whoever chose that license doesn't give a hoot about compliance, right? So it can't be high risk, right? Okay, so that's just a practical response. I find that I'm giving, best practices advice a lot more than, pure legal truth, of which we know very little in this area. The good, not evil license is also interesting because, I have told clients for a long time that if they can't prove that they're not evil, then they have bigger problems than this license. And that's a little bit of a flippant answer, but again, there's been no enforcement of that license, and so it ends up not being a practical problem. There is a movement to actually be a lot more specific about what good and evil means, and this is the so-called ethical licensing movement. Those are a different story, and I would actually not recommend that people adopt software and those licenses without a lot of extremely careful thought, because what you're doing is you're, basically saying, okay, if I violate human rights or the labor laws or whatever, or the vaccination laws or whatever that license particularly is mentioning, I am opening myself up to an extremely embarrassing public lawsuit about it. So I would kind of stay away from those. But WTF and good, not evil have historically been on everybody's, green list for a long time.
Wonderful. Heather Meeker, thank you so much for joining us today. From all of us at the audience, we really appreciate your wisdom and your advice, and this has been a super fun session.
Well, thanks, Kevin. I really appreciate it. It was great.
Yes, thank you, Kevin. Thank you, Heather. So what are the next steps? I will show my slides here real quick. And our next step for our listeners, one of our FOSSA reps will reach out to you to collect your shipping address so that we can get you Heather Meeker's new book, Open Source for Business, a practical guide to open source software licensing. If you have any additional questions, please go to fossa.com or contact us at sales@fossa.com. And if you would like to hear more about Heather Meeker, please visit her at this website, heathermeeker.com, about me. And for those individuals that are watching this post live, if you mention I love open source, we'll be happy to send you Heather Meeker's book after this event has gone live. So thank you, everybody. Thank you for your time. And we hope that you enjoyed our presentation.